I end a lot of my videos saying, be thankful for this specific thing, or don't take that one thing for granted. It might be your freedom. It might be your boots. In one video I said, don't take your boots for granted. Something that I haven't really pointed out is one should not take one's health for granted. Some people have perfect health. They're sound of mind and body, as physically fit and as mentally fit as they can be. They wake up with no aches and pains. They deal with their stress perfectly throughout the day. I think the rest of us admit that we fall short of that standard. Things aren't perfect. Perhaps we have a knee that aches whenever we wake up, or our back gets just a little bit tight when it rains. Some of us might just be a little bit depressed, slow in the winter months whenever it's darker and colder. Whatever your specific physical infirmity might be, if you can't be grateful for your perfect health, at least be grateful that you don't have to deal with that infirmity while incarcerated. You see, there are 100 pernicious details that interfere with your everyday life in prison. If you have even just a small infirmity, a limp or a cough or anything like that, prison is a hard enough place without something to make it harder. And don't expect that you're going to receive quality or even adequate medical care while incarcerated. It should come as no surprise that the best doctors and surgeons in the world, they don't practice on inmates unless they happen to be literally practicing on inmates. It was found that the standard of medical care in CDCR, that's the California Department of Corrections and Rehabilitation, was of such a low quality that it violated their Eighth Amendment rights. It qualified as cruel and unusual punishment. To be clear, I don't mean that there was a specific inmate who received such a low standard of medical care that he was cruelly punished. Nor do I mean that this was the standard of care in the system for a given time period, a couple of months or a year. I mean that it was the finding of the United States Supreme Court over a 25-year time period from 1990 until 2015, is whenever they finally let the receivership go, that CDCR failed to meet the minimum standard of medical care required in order to not qualify as cruel and unusual punishment. This was originally called the Plata case and regarded disabilities and disabled people in prison and what their rights were. It was later expanded to be called Plata et al., the Armstrong Remedial Plan, and the Coleman Plan, respectively. These were deals that were made between CDCR and the inmates that were suing, and more accurately, the United States Supreme Court, as to what the standard of medical care that would be acceptable was by the court. The court pointed out that while prison should not be an ideal place, it shouldn't be a wonderful place, it's supposed to be bad or people would want to go there. If you have a hypothetical inmate who has been sentenced to 2 years for a serious crime, but one which is perhaps understandable, let's say that he drank too much and his judgment was impaired, and he happens to have clipped a cop car while speeding and driving drunk. Nobody was injured, and he immediately pulled over and understood the incredible mistake that he had made, but with a mistake of that magnitude, yes, he had to do time. And so the court sentences him to 4 years at the Substance Abuse Treatment Facility, SADF, there in Corcoran. He'll be out in 2. This is a reasonable amount of time. It's a reasonable punishment, and hopefully serves to rehabilitate him so he doesn't do it again. But he has no choice but to avail himself of the prison medical. There is no other option available to him. And as it turns out, SADF, Corcoran, PVSP, a couple of other prisons that are in the central California area were built in an area that has a fungus called coccidioidomycosis. It's more commonly called valley fever. and a lot of inmates got sick. I think tens of thousands showed some symptoms. There was a large lawsuit, and the court pointed out that this hypothetical inmate who might have contracted coccidioidomycosis, he would likely die, or at least reasonably die. And the prison was built with the knowledge that there was an environmental hazard, a toxin there. And then CDC failed to provide adequate medical care to this hypothetical inmate, John, the DUI guy. And as a result, he died. This was a de facto death penalty for driving drunk because there was a substandard level of medical care at the facility. John is a hypothetical DUI inmate, of course, but there were a lot of people who died from this specific circumstance, valley fever. As it turns out, I personally contracted valley fever, and I got to experience California's medical system from the inside. I had a good friend who also contracted valley fever, Adrian Torres, and he came incredibly close to dying from it. I saw a lot of, frankly, brutal horror stories of prison medical. And this court case, the Armstrong remedial decision, or Plata et al., or whatever they were calling it at the time, it dealt with the fact that CDC was not providing adequate medical care to inmates. CDC's logic was essentially, we don't have sufficient funds to provide this medical care. If we had more money, we'd build more prisons, we'd hire more doctors, there wouldn't be a problem. But since we don't have the money, well, the inmates will just have to get by. We're trying, but we don't have the money. This is a reasonable stance at first glance, but it does raise an interesting legal and even moral gray area. Imagine you're a hypothetical inmate who has a right. Rather than having it be medical care, let's just say lunch. The court has decided that he's entitled to 3 meals a day, and lunch is one of them. And CDC realizes, well, we don't have enough funding for lunch. We're just going to cut it out of the menu, and from now on, all the inmates will eat 2 meals a day, breakfast and dinner. They'll live. I mean, almost all of them at least. At what point do inmates get to say, well, this is no longer constitutional. You're starving us to death. Now it's not even breakfast and lunch. It's just breakfast. Now it's just the food we can buy off the canteen with our own money. At what point does the state no longer have an obligation to provide to inmates whatever needs they may need met in order to live healthfully and to not be suffering from what they call cruel and unusual punishment? Exactly where the standard of cruel and unusual punishment has, of course, differed through the years. You think of the early penitentiaries of the 1800s where you lived on bread and water and just sat in a cell for your year or 5 years or whatever it was with the Bible. Or the chain gangs where they had guys working from sun up till sundown, and then they put them in their cell with bread and water and a Bible. Today, that would almost certainly be viewed as cruel and unusual punishment, and the court would step in. So this is a pendulum that has swung and swung back. You see, the reason this was a 25-year court case and such a big deal is because if CDC didn't get their act together, if they didn't find some way to meet a standard of medical care that the court said they had to, and there were some wonderful examples of CDC just failing to meet that medical care. Well, if they didn't meet it, the court was going to step in and they were going to order inmates to be released. Just let them go, end their sentence. And that is not something that any court does lightly. Let inmates go out into the free populace, possibly to harm the community that they're released to. It's a heavy decision, and they did weigh the constitutional rights of the inmates against the safety and the preservation of the communities that they would be released to. The final decision of the court was that CDC was not attempting to fix their medical problems. The term they used was deliberately indifferent, meaning the CDC was aware that people were dying under their care from preventable illnesses, but they had decided that they weren't going to care, and so they deliberately didn't do anything. This was unconstitutional, and over the course of 25 years, the court did eventually order inmates to be released. And not just a couple, tens of thousands of California inmates were released under this law. This wasn't just an arbitrary release of whoever happened to be at the front of the line. They didn't pick inmates' names out of a hat or anything like that. Surprisingly, in other states, whenever this problem has been raised, that's exactly what they've done. As I understand it, in Texas, whenever the court told them that they had to release inmates because the quality of life in their prisons was so low that people were dying, well, Texas just announced that for the next couple of months, they were going to make 1 day worth 2 days or 4 days or 6 days or whatever it was. So somebody who had been sentenced to 6 months in prison, well, they could finish their term in just a month or two. And they did that until they had their population down to a manageable number. Thankfully, California did nothing so arbitrary. They actually made a list of criterion by which they would allow inmates an early release. And it was well thought out. Completing a long-term drug rehabilitation program, I believe it had to be a year, and they had specific criterion, well, that would get 6 months knocked off your sentence if you really tried. Getting your GED or your associate's degree or your bachelor's degree, if you didn't already have them whenever you came to prison, again, 6 months each. I had a friend who got a full year knocked off of his sentence for getting his bachelor's degree and his associate's degree over the course of about 3 years. Personally, I had 6 months knocked off for getting my associate's degree. I was supposed to parole in the very beginning of November of 2018, and instead I paroled on March 30th of 2018, and believe me, 6 months not in prison, you can't put a price on that. This subject came about because I was thinking of some of the horror stories that I saw while I was incarcerated, which frankly led me to believe that the court's decision that the medical treatment of the sick and elderly in CDC constituted cruel and unusual punishment and was an Eighth Amendment violation. That had to be accurate because I saw things that I couldn't believe happened in a first world country. This next week is Halloween week, I suppose. So I'm going to devote it to medical horror stories in prison because that's about the scariest thing that I saw that I can think of. Because you are under their care and their supervision, and they make the final decision as to what treatment you will or won't receive. Rather than focusing on illness and infirmity or even early release and getting an associate's degree at the end of this video, I'm going to go ahead and do a 180 and say, instead of focusing on being grateful, thankful for your health, be thankful for your infirmities. Whenever you are of perfect health, you're that guy who's never broken a bone, never recovered from an illness, never realized that he is mortal, that he's flesh and blood, and that it will be taken from him. Well, he doesn't really value, treasure the health he has remaining. The way that you really come to appreciate your health is by earning it, by suffering a little bit, breaking a bone, recovering from a serious injury, and then standing up and walking and realizing that you've recovered. So be thankful for your infirmities. They let you know you're healthy. Thank you for listening today.